Judge Arthur Engoron, the New York civil judge who has been listening to the civil fraud trial here in New York against Donald Trump, his adult children, most of them, and others, has issued a decision and order. It's fairly scathing, and you can tell he's fed up with Donald Trump. It's a decision and order on motion for a directed verdict. And just the language he uses in there is absolutely, you could tell he is just sick and tired of Donald Trump and his lawyers making the same tired argument over and over and over again without, and they don't listen to him, right? And I'm going to read it to you. It's short. It's only 3 pages. I'm going to read it to you because you'll hear it for yourself. But let me just summarize what this is. Essentially, there is what a directed verdict is, and it's normal to make a directed verdict. It's normal for a defense attorney to do it at the end of the plaintiff's case or the government's case or the prosecutor's case, depending on if you're civil or criminal. But in a civil case, you make it at the end of the government's case. You can even make it a second time after the rebuttal case. And what you're basically saying is whether you could do it if there's a jury trial or a judge trial. And basically what you do is you say that they didn't, whatever their burden of proof is, here it's preponderance of the evidence, which is a lower burden of proof than beyond the reasonable doubt. It's basically, if you take a scale and it's 50-50 and you put a feather on one side of the scale, so just the slightest bit more is a preponderance of the evidence, believe it or not. And so what you're saying is that they didn't meet that burden. And, but even if you take everything they say as true, they didn't meet the burden, and you'd ask for a directed verdict, kind of like what Judge Engoron did already for the government, on the government side, when he found, even before the trial started, that by a preponderance of the evidence, Attorney General Letitia James had proven her case through her allegations and through all of the discovery, the depositions, et cetera, and granted a motion for summary judgment in favor of the government for count 1, the persistent fraud charge under Executive Law 6312. So, and what they were asking for was that in the reverse, a directed verdict. What the defense was asking for was a directed verdict for them, which is like a summary judgment motion, but at the end of the government's case at trial. And so, but this decision on this directed verdict motion was just worth reading, because it starts with, at least 5 times during the recently concluded 10.5-week trial of this matter, defendants moved for a directed verdict. The first such time was at the close of the plaintiff's case, which is when defendants normally moved for such relief. This court took that motion and most of the others under advisement. It denied 2 of them on the spot, and at the close of the plaintiff's rebuttal case, the defendants requested permission to move yet again, pursuant to CPLR, Criminal Procedure Laws and Rules, 4401, for a directed verdict. The plaintiff, meaning Attorney General's office, opposed the request, but not wanting to impose an undue prior restraint, this court granted the request. The instant letter motion ensued, and this court hereby denies that motion and furthermore denies all the prior motions that the court previously took under advisement. And then he footnote 1. One such motion came immediately after the close of the testimony of Michael Cohen, whom defendants wishfully denominated plaintiff's star witness. In denying that motion, this court noted that the evidence of wrongdoing already admitted into evidence was voluminous. Then he goes on to say, rather than marshal and detail yet again the evidence in support of plaintiff's prima facie case and defendant's failure to do more than raise issues of fact, this court will highlight some of the fatal flaws in the instant motion. The most glaring flaw is to assume that the testimony of defendants' experts, notably Messrs. Jason Flemons and Eli Bartov, is true and accurate, or at least that the court, as the trier of fact, will accept it as true and accurate. Bartov, a tenured professor, all but proves that his testimony is that for $1 million or so, some experts will say whatever you want them to say. His overarching point was that the subject statements of financial condition were accurate in every respect, as this court has discussed in excruciating detail in its September 26, 2023 summary judgment decision, the statements of financial condition contain numerous obvious errors, and by doggedly attempting to justify every misstatement, Professor Bartov lost all credibility. And then he's footnote 2. Dr. Bartov suffered essentially the same fate, testifying before the Honorable Barry Ostriger in People versus ExxonMobil. The court rejects Dr. Bartov, so quote, he's quoting from this ExxonMobil case, the court rejects Dr. Bartov's expert testimony as unpersuasive, and in the case of his testimony about the Mobile Bay facility, finds Dr. Bartov's testimony to be flatly contradicted by the weight of the evidence. Wow. Talk about scathing for an NYU professor. I mean, there goes his career as an expert. I would never call him as an expert. The cross-examination of him is going to be just crushing, given now that he has been called out as utterly not credible and as a gun for hire for $1 million, that he'll say anything for money. I mean, that's just ridiculous cross-examination. He has zero credibility, which, experts, usually, if you are an expert, you testify more than once, you testify lots of times, and you have to call balls and strikes like you see them. Sometimes you call it for the defense, sometimes the prosecution, because you're an expert. You can't sell yourself as a gun for hire, because then you lose all credibility like he did here. So then he goes on to say, Mr. Flemons acknowledged that he had never valued property, much less that he was a valuation expert, but he attempted to opine on values. The crux of Mr. Flemons' testimony was that so long as defendants selected one of the methods that ASC 274 permits, then any numbers may be entered into such methodology regardless of their accuracy or relationship to reality. Mr. Flemons also inexplicably acknowledged that future income had to be discounted to present to present value on financial statement, while at the same time stating there were no generally accepted accounting principles departures where defendants failed to apply a discount rate for future income. He opined that Mazars, which is the accounting firm Trump used, that has, by the way, Mazars has said that you cannot count on us, do not trust our evaluations. I mean, they put a public statement out and he no longer is their accounting firm. He opined that Mazars should have followed up on items in the statements of financial condition, but then stated adamantly that it would have been highly unusual for Mazars to make an inquiry for any appraisals in the client's possession. Footnote 3, in any event, there's documentary evidence previously submitted to this court on the parties' summary judgment motions, conclusively establishing that Mazars did in fact make inquiries for appraisals, and we're told there were none. So I love how he calls out, he basically is doing, he's calling out the inconsistencies in the experts. He goes on to say, Judge Engoron, he was reluctant to acknowledge that an asset controlled by a third party cannot be considered cash, while also acknowledging that it was a red flag. Defendants persist in arguing that if a loan closes prior to the period during which the statute of limitations allows suit, then any required follow-up statements of financial conditions made during that period is somehow sacrosanct. That contention is belied by a plain reading of Executive Law 6312. By the law of the case doctrine, and perhaps most importantly by common sense. Oh, so he's saying basically that contention is belied by both the executive law, by the law of the case, meaning rulings that Judge Engoron has already made, and by common sense. So closing is not a get-out-of-jail-free card for future misstatements. All that 6312 requires is a false statement used in business. The subject financial statements fit that definition to a T. In their zeal to, quote, protect the record, defendants yet again raise the specter that plaintiff has no standing and no capacity to bring the instant action. This court has confidence that the Court of Appeals can easily reach and determine those arguments which personify frivolity. So he's basically saying that's a frivolous argument. Defendants' arguments against disgorgement, meaning the money that they're going to take, that the government's going to take back from the defense as ill-gotten gains. That's called disgorgement. So defendants' arguments against disgorgement fall short in three respects. Disgorgement does not depend on damages, a different concept. The testimony showed that lenders did rely in part on his statement of financial conditions and 6312 contemplates disgorgement. Disgorgement is the return of ill-gotten gains. If you pay a lower interest rate on a loan by overstating the value of any of your assets, thus lowering the perceived risk to the lender, your gains are ill-gotten. The lender has lost money, although the loss is not out of pocket, and so the loss is not what the law traditionally thinks of damages. That the instant lenders made millions of dollars and were happy with the transactions does not mean that they were not damaged by lending at lower interest rates than they otherwise would have. Michael McCarty's testimony credibly supported this, and moreover, the court detailed in his September 26, 2023 decision, it is well settled that the state has an interest in protecting the integrity of the marketplace. So furthermore, the lenders relied in part on the subject financial statements, as was made clear in the testimony of Nicholas Hay and Michael McCarty. Indeed, many of the lenders' calculations used by the statements of financial condition as their starting point, to which they often applied a standard quote-unquote haircut. Defendants also trot out two of their standard canards, that valuations are subjective and that the law only penalizes material deviations. These both fall into the category of let no one be fooled. Valuations, as elucidated ad nauseum in this trial, can be based on different criteria analyzed in different ways, but a lie is still a lie. Valuing occupied residence as if vacant, valuing restricted land as if unrestricted, and valuing an apartment as if it were triple its actual size, valuing property many times the amount of concealed appraisals, and valuing planned buildings as if completed and ready to rent, valuing golf courses with brand premium while claiming not to, and valuing restricted funds as cash are not subjective differences of opinion. They are misstatements at best and fraud at worst. Wow. If that paragraph does not summarize what his ruling is going to be, what his verdict is going to be, I mean, that is the most brilliantly put paragraph that sums up this case perfectly. Anyway, to continue, almost done. Defendants are correct that discrepancies in amounts must be material to be actionable. However, the evidence in the record is replete with examples of material misstatements. The size of the triplex, the discrepancies between the appraised values, and the amounts on the statements of financial conditions. The discrepancy in value between restricted property and unrestricted property, the undisclosed addition of brand value, and the amount of cash that was illiquid, future value listed as present value without discounting to its current value, etc. Finally, defendants attempt to fall back on alleged disclaimers in the statements of financial conditions. So if you recall, that's what Donald Trump calls the worthless clauses. And he goes on to say, as analyzed in the September 26, 2023 decision, the words at issue were simply Mazar's practice of ensuring that the issuer was responsible for the accuracy of the statements. They are not disclaimers at all. They are not defendant statements, and they certainly do not shield defendants from liability. If anything, they expose defendants to liability. So as previously ordered, post-trial briefs are due by January 5th and closing arguments will be held on January 11th, signed Judge Arthur Engoron. Now, what is Trump's response? Trump's response says, as stated by the relevant institutions, Judge Engoron, he starts with, okay, let me not summarize. As usual, completely biased Democrat Judge Arthur Engoron, without the benefit of a jury, denied our motion to have this political sham of a case dismissed. Engoron doesn't discuss his valuation of Mar-a-Lago at $18 million when it was worth at least 50 to 100 times that amount, but does discuss insignificant items that, when added up, are irrelevant and a very minimal part of my financial statements. The bank stated that we were an ideal customer, a premier client, more than qualified for the loans, which were not even needed, and that my financial statements were some of the best they'd ever seen. Likewise, there was no money lost by the banks, and as obviously corrupt, power-crazed New York Attorney General's star and only witness admitted on the stand that he lied, totally destroying the Attorney General's case. Likewise, there was no money lost by the insurance company. There was no money lost by anyone. There was no victim. In fact, these were all wonderful transactions. As stated by the relevant institutions, Judge Engoron challenges the highly respected expert witness for receiving fees, which is standard and accepted practice for expert witnesses. The ignorant judge did not even try to listen to the expert witness. This is a great insult to the man of impeccable character and qualifications. The judge ignores the law. The judge also dismisses the fact that there was a full and complete disclaimer clause, which tells the users of financial statements to do their own due diligence and analysis, something they openly and knowingly did and admitted to. This is a rigged lawsuit by a corrupt attorney general and judge and system who would not allow it to go to the commercial division or in front of a jury. There was no lie except for a judge's fake valuation of my property, such as Mar-a-Lago, which was valued at $18 million, in order to try to make the case, which doesn't exist. This corrupt witch hunt has to be stopped. I mean, it's crazy, right? On the one hand, it's like two people looking at the same thing, and one sees that the sky is blue, and the other sees that the sky is green. I mean, it's like they are looking at the same thing, but just seeing two completely different things. Anyway, it's completely clear by Judge Engoron's perfect ruling, to use a phrase Donald Trump would use, but it's actually an excellent ruling. How he's going to rule, what's going to happen, it's only a matter of how much the disgorged profits will be. And, it's absolutely clear that Judge Engoron, what his verdict is going to be in early January. And so Trump is going to do everything he can to try and spin it the way he wants to spin it. And that's what he did with that Truth Social piece. But the writing's on the wall. He's going to lose many, many millions, and he's going to lose the opportunity to do business in New York very soon. I'm Karen Friedman Agnifilo with Legal AF. Join me every Wednesday and Saturday with my co-host Ben Meiselas and Michael Popak. Thanks for listening.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.